Supreme Court Justice Ann Walsh Bradley is seeking her third term on the Wisconsin Supreme Court. The election is April 7th. Before her 1995 election and 2005 re-election to the court, she served as a Marathon County Circuit Court judge. Justice, welcome back to Wisconsin Eye.
Thanks, Steve. Glad to be here.
You have been on the bench for 20 years. I'm just curious, the biggest change in the dynamics and the synergy of the court over that 20-year period, ma'am?
I think one of the biggest changes isn't in the court itself, but in the process of getting elected to the Wisconsin Supreme Court. 20 years ago, there was strong belief in having a nonpartisan judiciary. In Wisconsin, what we did is we had strong bipartisan support. Many people now no longer believe in that. I think they want to insert political parties into our nonpartisan judiciary. So that's the biggest difference in running now, 20 years later, again for the Wisconsin Supreme Court.
And then some people say that a rather vigorous debate, as you're engaged in, is pretty good for the court, the future of the court. Do you agree? Or are these, I mean, I know you're having partisan versus nonpartisan is being discussed, but
yes.
The changes overall negative or
well,
good for the dialogue?
I think the influx of political parties into judicial campaigns and the consequence of that kind of influx, that is, as you well know, being such a dean, if you will.
Oh, thank you.
As you well know, the third branch of government relies on the public trust and confidence of the people for its legitimacy. You know, unlike the legislative branch, which has the power of the purse, and the executive branch, under the Constitution, the power of the militia, we have only the public trust and confidence of the people that gives us our legitimacy. That's our currency. And the problem with inserting political parties into judicial nonpartisan races is that political parties have agendas. It's that simple. And we don't want courts with agendas, and we don't want to be perceived as having a court with agenda, because that minimizes and diminishes the public trust and confidence of the people. So this is really a very important issue. My opponent and I have a very different vision of the judiciary in that regard.
Yes, you've gone through last week at the first forum. You went through a list of where he's met with local Republican Party organizations. Now, I have to ask, you've not met with any Democratic Party organizations?
That's correct, save one exception. I think it was in December or January. You know, I live in Wausau, and a friend of mine was getting some recognition, and I was asked to attend, and so I did that. But other than that, the answer is definitely no.
But the dialogue now regarding these races, because of the partisan overtones, is you're regarded, I'm not saying this, but you're regarded as a Democrat in the race. Your response, ma'am?
Well, I'm striving and working hard to make sure people understand the difference between the three branches of government, and that we have a nonpartisan judiciary. What I have done, I have people from both sides of the aisles. I have political leaders, including, as I think you know, former First Lady Republican Sue Ann Thompson, who's endorsing me, Ron Kind, a Democratic congressman from La Crosse, State Senator Dale Schultz, Republican from Richland Center, and even Tim Cullen, State Senator, Democrat, from my opponent's home county. They got together not all that long ago and wrote a letter to every editor in newspapers around the state, and they started the letter this way. They said, in this time of partisan divide, we come together to support the re-election of Justice Ann Walsh Bradley, because we too believe in the importance of maintaining a nonpartisan judiciary. And I think people really want that. As I travel around the state, I hear concerns. They want a level playing field. They want to make sure they get a fair shake when they come to court. You know, they don't want to be asked or have the concern of being asked, you know, are you a Democrat or are you a Republican when you file, you know, your court papers or come to court? Unlike, again, the legislative branch and the executive branch, the courts are special. We have a special role to play in this constitutional scheme of three branches of government: fair, neutral, impartial, nonpartisan.
Then what rules do you put in place, both in your personal and professional life, to make sure that you don't become partisan or perceived as partisan, Your Honor?
Well, I've worked hard for that. You know, I've worked. Part of a good example of that is the very campaign that I am running now. And I won't mention the person's name, but just this morning, an email was forwarded to me. A very well-recognized Republican in the state was contacting my campaign and saying, where can I contribute? I've worked hard to maintain relationships on both sides of the aisle because that's the way we should be doing it in Wisconsin. That's the way, as you know, we've traditionally done it. We have strong bipartisan support in order to maintain a nonpartisan judiciary. I need, want, and have support from Republicans, Democrats, independents, and folks from around the state. And that's the way it should be in a judicial race, I believe. That's my vision, Steve.
Let's talk about the divisions on the court. They're obvious to those of us that watch the administrative hearings. Are those, it looks to us that those are both professional and personal differences. Are they?
Well, I think all 7 of us know that we have to do better and strive to do better. Sometimes we succeed more often than other times, but we've had some challenging times in the last 4 years on the court. And we know that the people want and deserve better. And all 7 of us, in our own ways, are striving to do that. You mentioned watching administrative hearings. You also cover, of course, our oral arguments when attorneys come to court and they argue their case before all 7 of us. We ask questions of the attorneys, and then we go back into the conference room. And I think people would be quite satisfied with the tone and level of discussion. It is professional and it is civil, and that's what people want, and we're striving to accomplish that.
There's a school of thought that said collegiality, I'm overstating it, doesn't really matter, but it is less important if the court does its business, and that is disposes of all the cases pending before it adjourns for the next term. Do you subscribe to that?
Well, I thought you were going to end your sentence, collegiality breeds contempt, because that's the theory I've heard.
I've actually heard it both ways, so however you want to respond.
Well, you know,
How important is collegiality?
Collegiality, just from a human experience. You know, we are all justices, but we all happen to be also very engaged human beings.
Strong,
that's right.
Proactive people, or you wouldn't be on the Supreme Court.
No, but it is easier to be collegial. You know, we are what we call in appellate practice a collegial court, but by that we mean that we come together, we discuss cases, and decide cases together. So technically, that's the label you put on a court like us, a collegial court.
The word that I've heard is the D word. Is the court dysfunctional in terms of its personal interactions, Your Honor? Well,
I have the same response. We've had challenges. I understand that label has been used in the past. We've had challenges, but we really are trying, Steve. We know what the people of this state want, deserve, and expect. And I think all 7 of us are striving to do that.
Obviously, you're strong-willed, or you wouldn't have spent 20 years on the court. Is there anything you've done that contribute to the lack of collegiality? Anything you'd like back? Any mistakes in what you may have said interacting with the other justices, Your Honor?
Nothing specific comes to mind, no.
Okay. Okay. The next step in potential collegiality, the constitutional amendment on the ballot, April 7th.
Yes.
That would reverse how many years of tradition?
126 years.
126 years. If that passes, is that going to be a step towards even a more fractured court, Justice?
Well, it has that potential. I know one of the arguments advanced is that it will bring greater collegiality, but I think that common experience of a lot of folks would say, look, if there is a campaign every 2 years and people are jockeying for a position, that doesn't always bode well for enhanced collegiality.
Is this is a constitutional amendment just a brazen attempt to force out the Chief Justice, Your Honor?
Well, I'll let the adjective for you, but it is an attempt to get rid of the Chief Justice. You know, my former colleague, Janine Geske, who served with me for many years on the court, she provided written testimony to the Judiciary Committee last January when they were deciding whether or not to put this constitutional referendum on the April 7th ballot.
Yes.
And Janine said this. She said, it's obvious that it's targeted to get rid of Chief Justice Shirley Abrahamson. And she went on to say that, in her opinion, to change the Constitution because you don't like the style of an individual person would be a, and I quote, terrible mistake. And I agree with Janine. You know, I've been on the court for 20 years. I know a lot of justices on other Supreme Courts of the states in the nation. And there are varying ways to select a Chief Justice, strengths and weaknesses to all of those. And which is the best way, I think, is debatable. But what is not debatable is that you don't use the Constitution, which I consider to be a sacred document. It defines who we are as a people in this state and what we believe in. And to use that as a tool for political payback is not what constitutional amendments are for, just because you don't like some individual person's decision. So I'm hoping people will vote no on the constitutional amendment.
What would the court lose if Chief Justice Shirley were no longer Chief Justice, Your Honor?
Leadership matters, doesn't it? Leadership matters in terms of developing a vision for the court. Her vote on cases is just one of 7, right? But in terms of leading the court system, you know, we've been considered in the past one of the leaders in so many different areas, whether it is trying to respond to the needs of people who cannot afford coming to court, not just in criminal cases, but in civil cases. We've been leaders in areas of making sure that the courts are open and accessible to people, leaders in court interpreters, leaders in advancing alternative court treatment programs. So, and a lot of that actually was initiated by her leadership. Certainly it takes all of us, right? It takes not only all of us on the court, but it takes the many circuit court judges and court of appeals judges around the state to bring these programs to fruition. But it takes a leadership vision to start these programs. So leadership matters.
On the issue of the Chief Justice, I want to read a statement today that the Judge Daley campaign put out. And it deals with you. Lost in Bradley's throaty defense of her opposition to the constitutional amendment is the fact that she's next in line to be Chief Justice. That almost says you have a conflict of interest in this debate. Do you want to respond? I mean, I assume, given 20 years on the court, you might like to be Chief Justice, but do you have a response to the statement today?
Well, my focus is on getting reelected as a justice to the Wisconsin Supreme Court. My focus is going around the state, talking to the people in all corners of the state and every place in between, telling them about my vision for the court, a court system and court campaigns that are free of political parties being injected into the court system and to the campaigns, that's willing to stand up against out-of-state special interest money, which has outsized influence and is playing outsized influence and roles, rather, in our campaigns. And the reason that's of such concern to me, and is part of the reason why I'm running for re-election, is that those groups have agendas, unknown agendas, undisclosed donors, unlimited money. And the result is the public trust and confidence in the judiciary is undermined by what's happening. I want to try to change that. I want to try to change the direction and make sure that people share a vision of the court that's fair, impartial, nonpartisan, not beholding to any special interest group. You know, that people want to make sure when they come to court, or their neighbors come to court, their friends come to court, they're going to get a fair shake. And I don't care how powerful any organization is or powerless. People want to make sure they're treated equally, regardless if they're young or old, fat or thin, powerful or powerless. Everyone deserves a fair shake when they come to our court system.
What's your response to Judge Daley's ad, which says that your record is trying to block the agenda of Governor Walker?
I'm appalled at the ad. And I'm appalled at the ad because it either misrepresents or misunderstands the role of the Supreme Court in this state or a Supreme Court justice. Our role is not to be opposing or supporting any political agenda. Our only agenda is to support the Constitution of this state and serve the people of Wisconsin. So it's that kind of ad which just adds fuel to the fire of misunderstanding what the role of the courts are and injecting political parties into our nonpartisan court system. So I would expect more from him. I think he knows better. I think they're just doing this as he knows better, I think.
Well, and when the Daley campaign criticizes your decisions on Act 10 and Second Amendment issues, I presume you're convinced you got those issues right, those opinions right, Your Honor?
Well, I don't have necessarily, when you say those issues, I mean...
Those cases?
Those cases. Again, we have to make sure we're talking about that it is not the role of the judiciary to say, oh, I'm in favor of Act 10, I'm against Act 10. We aren't supposed to be in favor or against any political agenda or policy. When cases come to us, they are very discrete issues, very nuanced issues. What does this section of the state constitution mean when it says the doors of the legislative houses shall be open? I mean, that's the kind. What are the issues in terms of what is the requisite timing and method for publication of a law? So it's not a matter of being for or against any political party. And to continue that dialogue really misrepresents to the people what the role of the courts is. I have spent 20 years, I have a proven record, of traveling around the state and talking to people about the importance of the third branch of government. In my summer, during the summertime, I travel around the states speaking to boys and girls clubs about the importance of the role of the courts. 2 weeks ago, I was speaking with a group of social studies teachers. I regularly talk to students. I've received a national award. In fact, Sandra Day O'Connor has a civics education program that is focused on people understanding the proper role of the court, and I'm the co-chair of her program in this state, which causes me to have spent years making sure that people have a greater understanding of the role of the courts. And then you get ads like this, which are just so counterproductive.
I just want to ask you about one more ad. When I interviewed Judge Daley, I asked him about one of your ads, so I want to ask you about one of his. Mm-hmm. The and/or ad, which he says, your opinion, could have released some vicious criminal. I just want to get your response to that, the and/or issue. You remember that?
I think that was a case that was Judge Daley's case. I think it's called the Anderson case. It kind of underscores, he has taken issue and thrown certain labels against me in this campaign consistently. And I think it boils down to, it's not so much the way that I view the law or approach the law or study the law. Sometimes he just doesn't like the bottom line of my decisions, and I think that's what's going on there. So that was a case where he apparently, it was alleged he had made a mistake in the jury instruction using a conjunction when there should have been a different and or an or.
Okay.
And unanimous Court of Appeals said he made a mistake. When both parties came to the court, not only the defense said he made a mistake, but the state said he made a mistake, but the mistake was harmless. And there were, I think, 3 of the judges justices on, or 4 of the justices on the court, who kind of reached out and decided an issue that wasn't briefed or argued, and that's how that case unfolded. So, you know, that's the way I saw it. That's the way Unanimous Court of Appeals saw it. That's the way both parties who were arguing the case saw it, that Judge Daley had made a mistake. You know.
The campaign finance dimensions of this are interesting. I just want to quote Kevin Kennedy yesterday in testimony before the legislature. Told legislators that recent court rulings made campaign finance laws totally inadequate. His term, not mine. Mm-hmm. What fundraising rules or prohibitions have you put in place in light of the question whether there are any limits anymore?
Well, of course, right now in the state there remains certain limits. The 10,000 limits for contributions of organizations, $8,625. Those limits are still in effect.
Okay.
Tell you what I've done. A few years ago, the court passed rules regarding recusal, and we had petitions before us with regard to limitations of contributions. In my mind, the court passed rules that were not tough enough. So what I've done in this campaign is holding myself, and I think the courts should be held to a higher standard. I've instructed my campaign not to accept any contribution from an attorney who has a case currently pending before the court. That's not required, but I think it's the right thing to do. I've instructed my campaign committee not to accept, not to solicit, not to accept any contribution from a party who has a case pending currently before the court. You can do that, but I don't think that's what we should be doing. I think we should hold ourselves to a higher standard, and that's what I'm trying to do.
As this debate over campaign finance issues evolves, do you think corporations should be able to donate? Wisconsin has had a prohibition, and that's one of the things, that prohibition is one of the things Kevin Kennedy mentioned yesterday. Do you think corporations should be able to donate?
The United States Supreme Court has weighed into this issue. We are bound by the precedent of the United States Supreme Court. So legally, that portion of it is decided to a certain extent. But I'll tell you, the consequence is difficult for judicial campaigns. Unlike executive branch, unlike legislative branch, it's just different. You can expect a little more give and take, and a little more partisanship and agendas. You know, political parties, special interest groups have agendas, and so does the executive branch, and so does the legislative branch. So it works better in those kinds of races, Steve. Judicial branch of government is to have no agendas except fidelity to the law. So it makes the legal precedent difficult to work with. That's the practical consequence. But the law is established by the United States Supreme Court, and we are required to follow that.
Do you want third-party groups to, even though they have every legal right to run independent ads in your campaign, that might help you get reelected, are you asking them to not run those just because of some of these issues that you've just outlined, Your Honor?
If you mean by third-party groups, these kind of out-of-state special interest groups, or
yes,
these groups with unlimited amount of money,
yes,
unknown donors, and unknown agendas, I think they're harmful to our judicial system. I think because, as I said before, the agendas that these groups have, the unknown agendas, undermines the public trust and confidence that the people have. So I think that we have to stand up and say no to these out-of-state special interest groups. Let me put this in perspective. I'll tell you why. This is not business as usual. Wisconsin is second in the nation of having special interest groups contribute and buy political ads in judicial races. Second in the nation. Now, Steve, generally I like it when Wisconsin's at the top of some list, but this is the wrong list. It's headed in the wrong direction. Wisconsin has a problem, and we've got to stand up to that problem.
Then it sounds like when you decide whether to step off a case, no justice has to give a reason, but one of your criteria, this is a question, is one of your criteria who has contributed to your past campaigns, and whether third-party groups have been active in your campaign who may have an issue pending before the court, and any amount, $5,000, $10,000. So what criteria will you use if reelected on when to step aside?
What judges and justices do, we have certain statutory rules. We have Supreme Court ethics rules that I spoke of before. And then, of course, we have our prior case law and that of the United States Supreme Court. So a judge or justice would normally do this. And then we have advisory opinions also in terms of ethics. You'd look at the statute, 757-19. That sets forth when you are disqualified, when you shouldn't be sitting in the case. You look at our Supreme Court ethics rules, 6006.4, and see if any of those apply. You look at the advisory opinions, and then you look at cases. One of the cases that comes up oftentimes is this case by the United States Supreme Court called Caperton, and that addresses
out of West Virginia.
Out of West Virginia, $3 million contribution. Coal mine owner had a $50 million punitive damage award, and he made a decision. The best way to handle that is to give $3 million to a challenger who is running for the West Virginia Supreme Court. The challenger won, and then sat on that case, the $50 million punitive damage case. 3 times Justice Benjamin, the challenger, said, "No, I can be fair, I can be fair." The case went to the United States Supreme Court, and the United States Supreme Court said, even though you're saying you can be fair, and you may believe you can be fair, that it raises such a serious risk of actual bias that's a constitutional violation of due process, of not having a fair trial.
But just to clarify, you're not aware of any Caperton-like cases in Wisconsin, are you, Your Honor?
No, you asked, yes, what process you go through, and that's the kind of process you go through in deciding whether or not you're going to sit on the case. You look at that precedent and the advisory opinions.
Is there one opinion that you've written maybe in the last few years that you have such pride in, you'd like lawyers and voters watching the show to look up? Anything, any one decision you have a special pride in, Your Honor?
Well, I mentioned when we changed our code of ethics dealing with campaign activity and recusal rules, I wrote a dissent, and it was a strong dissent because I thought we were headed in the wrong direction. I remember at that time former Justice Bill Bablich was no longer on the court, and he was at that hearing, and he had actually filed a petition to help us also decide what's the best way to change our rules. He couldn't believe what the majority did. He also thought that they were headed in the wrong direction. So I wrote a dissent. That dissent has been quoted nationwide for the last 4 years. You'll find it in several writings. So that's a good source of how I see and have responded at least to that issue.
Maybe I can't do this, and I know you well enough to know you'll tell me if I can't. You have recused yourself from the John Doe oral arguments. Can I ask you this question? Do you believe they should be argued in open court? I'm not asking you on the merits, but can you answer that or no?
You asked me what... this is a decision really for the justices who are sitting on the case. So I guess that's the best way I can respond. I have participated in a lot of decisions in the Wisconsin Supreme Court dealing with open meetings, dealing with public records issues, and my record has consistently been for one of open and accessible government. But the justices that are sitting on the case are going to have to decide this issue before them, at least at this time.
Okay, we're almost out of time. I have 3 quick questions. The governor wants to move the Judicial Commission directly under the Supreme Court. Would that be a wise or not wise move, Your Honor?
I don't think it would be a wise move, and it's not just my thought, it's the thought of the other justices, and it's the thought of the Judicial Commission. The Judicial Commission is responsible for prosecuting professional misconduct, and to have the people that they are charged with overseeing their budget raises concerns, I think, for all of us involved.
The Supreme Court heads the 3rd branch of government. it intrigues me that the Department of Administration has ordered the judicial branch of government to return, I checked this with Fiscal Bureau, $11.8 million from its operating budget on June 30th, the end of the fiscal year. Is that an improper interference between the three branches of government, Your Honor?
The budget is unfolding, as you know. The legislators are traveling around the state and having hearings, and so there's still some give and take in the whole budget process. And so we'll see how that unfolds, Steve.
But if the judicial branch returns 11.8, which is a number that DOA wants on June 30th, is that going to hurt the functions of the Supreme Court, the Court of Appeals, and Circuit Court?
No, we're tight on money. Certainly we're tight on money. As we talk to our different committees, we met with in the last several weeks one group called Access to Justice. That group had requested and is requesting $5 million to help with legal services for those who can't afford in certain areas of law, who just totally don't have access to the court. And you know, that's something that we're looking for, that would be really important for our system to function well in this state. There are a number of issues that we're concerned about. You raised the Judicial Commission. That's one. But the power of the purse is in the legislative branch, but that doesn't mean that the judicial branch doesn't have a responsibility under the Constitution and the power under the Constitution to fulfill that responsibility.
Another issue, and this is my final question, another issue being discussed in the Capitol, in the Senate and the Assembly, is whether judges on the Supreme Court should face a mandatory retirement age of 75. Your position on that?
I'm much too young to think about that.
I understand that, but there's a principle being debated.
A principle being debated. Look, the legislature can, under the law, give a mandatory retirement age. That's what the law says. And it's up to them to decide whether or not that's the wisdom of that. I've heard arguments, of course, in response to, well, the legislature doesn't have a mandatory retirement, the governor doesn't have a mandatory retirement. And again, my concern would be if it is so nuanced, it is targeting one person and one person only. So legislature has the power to do it. Whether it's wise and what it'll be, we'll see how that unfolds. It doesn't seem to me, Steve, that legislation is really advancing very quickly.
Understand. Justice Ann Walsh Bradley seeking a third term on the Wisconsin Supreme Court. The election is April 7th. Thank you so much for talking to Wisconsin Eye.
Thank you, Steve.
Thank you.